The Ninth Circuit Federal Court of Appeals has decided that landlords in Seattle can ask their tenants about their background history. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have an interesting article for you today, and it's going over the criminal case that they had. All right, so I have an interesting article for you today, and it's going over the case that they had against the Seattle law that said that landlords can't look at their tenants' background histories. Now, obviously, the background investigation is one of the best tools that landlords have to screen their tenants to make sure they're putting good people into their properties. The last thing we want is to put a tenant in our property who's going to tear the place up, terrorize our other tenants, and cause trouble overall. The worst thing, though, is not getting paid the rent. And by using the background investigation, we're able to better determine who the best tenant can be for our property. But Seattle and other cities like it have decided that, hey, landlords, they're discriminating when they're using background investigations. No, no, we're not. We are making smart business decisions, and you know what? It's a great tool to have and have available. So, you know what? I don't like that they said landlords can't use this. So, the decision that the Ninth Circuit Court of Appeals made is kind of a split decision, and I'm going to explain that a little bit more as we get into more details from this article. So before I get into the article, go ahead, hit the like and subscribe button, maybe leave a comment down below and let me know what you think. Do you think landlords need background investigations in order to do a good screening for their prospective tenants? Obviously, I'm a landlord, I'm biased, but I do believe even if I wasn't a landlord, I would understand why landlords use background investigations and think that it is absolutely necessary. As a tenant, you would think that most other tenants would be like, well, I don't want to be living next to criminals. I don't want to be living next to people who have, convictions for theft or drug dealing or other problems that they don't want, having their neighbors to have. Obviously, the best thing would be if landlords were able to make the decisions regarding their business without government intervention. Unfortunately, in places like Seattle and other progressive places, the government wants to be involved in everything. They want to make all the decisions, and they're driving landlords out of business. That's the truth. They're driving landlords away. They're telling landlords, hey, we don't think that you need to be here. Well, you know what? They still need housing. People need affordable housing. And unfortunately, when they put all these rules and regulations on us, housing becomes more expensive. So I'm sitting here in Honolulu, Hawaii right now. I'm on a work trip. So that's why my background looks a little bit different. But let's get into this article and see what it says. This article is coming from kuow.org, and it says Federal court rules Seattle landlords can ask about criminal history. Part of the decision is good, part of it is not so good. So let's get into the article and see what it says. A federal court has struck down half of Seattle's Fair Chance Housing Ordinance. The ordinance, passed by the Seattle City Council in 2017, prohibits landlords from asking about prospective tenants' criminal history. It was backed by then City Council member Bruce Harrell, the city's current mayor, to protect people with criminal histories from housing discrimination. Maybe people with certain criminal histories deserve to be discriminated against. Okay, I mean, think about crimes against children. Think about people with domestic violence. I mean, do you want these people in your property? I mentioned theft before. Landlords have a good reason to screen. And no, we're not just blindly denying everyone. Well, some landlords are, but you know what? That's their right. They should have the right to blindly deny people for their criminal history. Oh, yeah, you have a conviction from 20 years ago, but that could still be relevant to today, especially if your conviction was 20 years ago, but you just got out of prison, okay? Or your conviction was 20 years ago, but it was for an especially serious crime, such as crimes, yeah, like I said, crimes against children. So, yeah, I think that your criminal history is 100% relevant. If a landlord wants to say, hey, I don't want any people with felony convictions living in my unit, then that should be up to the landlord. And unfortunately, the truth of the matter is that you are going to be rejecting a lot of people, and it's going to be harder for them to find housing. So that is one of the consequences, though, of committing crime. But the Rental Housing Association sued, saying it violated landlord rights. On Tuesday, the Ninth Circuit Court of Appeals agreed. The court ruled that banning landlords from asking about criminal history violates their First Amendment rights. The Housing Association is celebrating this as a win for landlords, said Executive Director Sean Flynn. I think this is the appellate court pushing back on where the city of Seattle has legislatively infringed on our constitutional rights, Flynn said, and we hope that and challenge the city of Seattle to do better in the future. Flynn said laws still remain that are attempting to fix the problem of discrimination in our society, but he said this ruling says to them that governments can't pass laws that stifle our free speech in order to fix those problems of discrimination. Yeah, I mean, when you think about it, it is free speech to be able to ask somebody about their criminal history. Okay, now uh, I'm surprised. The Ninth Circuit Court of Appeals is known as being one of the most liberal of the appeals courts within the entire country. So, yeah, it's surprising that even part of this law was struck down, but part of it wasn't struck down. And what exactly was that? Well, let me explain as we continue. But Seattle's fair chance law is still partially in place after today's ruling. The federal appeals court upheld the second half of the law, which is about what landlords do with the criminal history information. Seattle prohibits landlords from denying a person tenancy based on their criminal past. That will remain illegal in Seattle. So landlords are looking at this like it's a victory. Well, it's a partial victory, right? You can still ask about the criminal history, but you in no way can deny a person with the criminal history housing. Okay? So you're still stuck with housing people in your unit with horrible criminal histories. So let's say that there is a person who has a crime of violence against the child, and you have a duplex, and now you're putting in them. You have to put them in there next to a family with children. I mean, think about that. That would be what the Seattle law is telling landlords they have to do. They have to abide by the law, but you know about it too. That's the worst part. You would know that this guy has these criminal convictions, but no, you also can't do anything about it. So it puts landlords in a bad situation where if anything does happen, then everyone's going to come after a landlord and say, well, why did you put that guy in the unit? You knew he had this criminal history. You knew that he was possibly going to be trouble for your other tenants. So why did you do that? So yeah, you're putting landlords in a bad situation where you say, well, we can look at the criminal history, but we can't reject the tenant. I'd much rather just not look at it, and at least then I wouldn't feel guilty about putting a bad tenant in there and something bad possibly happening. Okay. Oh, gee, you know what? This is a loss still. And I think that the landlords, the best thing to do would be to continue to push this law all the way up to the Supreme Court. I mean, we need the whole law thrown out, not just the half of the law. The whole thing needs to be thrown out because it takes away the discretion of landlords to decide who and who isn't going to be living in their property.